Hello, welcome to our webinar. Today we're going to talk about sex, drugs, and human resources in the workplace. We are sponsored today by Landrum HR and by Clark Partington Law Firm. We're going to talk about a variety of topics including sexual harassment, drug-free workplaces, a variety of human resource issues, and we're also going to talk about cybersecurity. Today our first guest is Daniel Harrell, who's a partner with the law firm of Clark Partington here in Pensacola. Daniel, can you take a moment and tell us about your law firm?
Sure. Clark Partington is a full-service firm located, headquartered in Pensacola. We've got 5 offices between Orange Beach, Alabama, and Tallahassee, so we cover the entire panhandle of Florida and the Gulf Coast, including office in Alabama. My particular practice is a litigation practice focused on employment issues and a lot of employment counseling as well.
Okay. And does your law firm handle things other than employment law?
Sure, absolutely. We can handle any form of litigation. We do lawyers that do nothing but transactional work, and we really have a broad set of lawyers that can cover almost any issue for any company.
So you're a full-service law firm?
Absolutely.
Okay. Well, today we're going to focus on employment law issues, and I'd like to start with sexual harassment.
Okay.
It has certainly been on the front page of every newspaper and every magazine, and it seems like every time I turn on a news program, there has been another high-power male who's been accused and sometimes apologizing for inappropriate behavior in the workplace.
Sure.
I would think that one of the keys to preventing this in the workplace is being proactive.
Absolutely.
Can you talk a little first about what sexual harassment is and what an employer might do to spot it and prevent it?
Sure. Well, sexual harassment has a couple of different connotations. One is what I think the public thinks of and what a lot of what we've seen in the media in the last several months. The second kind of specific connotation would be the legal one, which requires certain specific things to have occurred in order for there to be a legal, viable claim for sexual harassment. But an employer really shouldn't make much of a difference between those two, because even if you have an issue with sexual harassment that doesn't rise to the level of a legal problem, it's still going to be a workforce issue.
I agree.
And ultimately, employers need to take the right steps to make sure that they are given the information they need at the right points in time so that they know what is happening and what they can do to stop it. And that really means that ultimately the employers need to put the right safeguards in place through policies, through training, and by making sure that the Human Resources Department is a critical piece of the component when someone believes that they're having trouble with any sort of harassment.
And from a proactive standpoint, I would think that transparency would be key in terms of having a healthy workforce where somebody feels free to come forward and say, hey, this doesn't feel right, whether it's legally sexual harassment or just maybe uncomfortable behavior. There has to be some feeling that employees have where they are free to come forward without fear of retaliation. Absolutely.
You know, what we're seeing in the media now is a big move towards people coming forward and letting the public know or letting other people know what they're experiencing. Mm-hmm. And that's a great opportunity for employers to, at this point in time, look at their policies, look at how issues like this are being handled in their workforce, and make sure that they're doing the right things to protect employees and to provide employees with what they need in order to feel comfortable in coming forth, because an employer is ultimately protected under the law if they do the right things up front, and if when a complaint occurs, they take the right action to make sure that the issues are resolved appropriately. If an employer turns a blind eye to these issues and doesn't do the right things right now to make sure that they have the right policies in place and that their employees know what they're supposed to do, that is really the issue that is going to create scenarios of liability for employers moving forward.
Yeah, so one of the common questions I've heard over the years is, I may be an employee with a complaint, but I want to keep it confidential because it makes me a little uncomfortable to talk about. How does an employer respond to a request for confidentiality?
Well, there's a request for confidentiality is something that's important, but writing into the policies what the expectations should be is really the key way to make sure that employees don't feel like they've made a complaint and then they've been treated poorly because of that. And the best way to do that is to, within certain policies, write in that the company will do everything it can to maintain confidentiality. But as you and I both know through working through these issues, oftentimes to conduct an appropriate investigation, you have to let a number of people know what the situation is. And as much as a company wants to be able to try to maintain absolute confidentiality, it's nearly impossible to do that in a lot of settings. So by putting into the policy and by relaying to an employee up front that we're going to do everything we can to make sure that this issue is maintained in a confidential setup, letting them know that appropriate action needs to be taken in investigation so that the issue can be resolved. The other thing that helps out is letting the employee know that retaliation is something that will never be tolerated within the company. And if something gets out and someone takes a negative action against them, they have a person they can go to. And what I'm telling clients currently is that that person needs to be laid out specifically. If you have a problem, call so-and-so at such and such number, or email so-and-so at such and such address. And if you lay that out for them, they're put in a position where, while you may not be able to ultimately keep it absolutely confidential, you've given them the tools they need, that if they feel like they're being retaliated against, they go to the right person, and that issue can be nipped in the bud.
I agree, especially about the retaliation portion. So tell me, so far we've seen a lot of women come out, but other people are protected under the law as well. It's not just a law to protect women.
That's correct. We have seen over the last 20 years an increasing number of issues with female harassment of females harassing males, males harassing other males. This doesn't just cut across one segment, it cuts across all segments. And there's been a underlying concept of, well, the only ones that really matter are males harassing females. That's the only ones that anybody pays attention to. The law makes there's no difference in the law between the type of harassment. Any sort of harassment on the basis of gender or of a sexual nature is something that should be reported and should be dealt with seriously. And managers, frontline managers, need to be made aware that this isn't just a male-female issue, but it can create issues across lines, and those need to be taken very seriously, because we're seeing more and more of that as the workforce continues to see more openly homosexual people in management positions and more females in positions managing males.
So the law covers or provides protection for the LGBT community as well.
Absolutely. There is right now there's some lack of clarity as to what Title VII protects, but with a sexually hostile work environment, my belief, based off the case law, is that there is protection, and an employer who doesn't recognize that at this stage is running an incredible risk, just based off the plain language of Title VII, the statute.
And the guidance provided by the EEOC, it's very, very clear.
That's correct.
Yeah. So let's switch gears a little bit to medical marijuana. So medical marijuana is a very confusing topic, because there are a lot of states that have recreational use, like California and Colorado. And then there are, I think, 24 states that have medical use allowed by marijuana. And then there are many states that don't allow either. And then there's the federal government. So can you help us piece those various laws together? How do they all play?
I can provide a little bit of guidance, but one thing that I think is important to point out to employers at this stage is that we are on the precipice of this issue. This issue hasn't really evolved to a point where it's very easy or very safe to say, here's exactly how you need to manage certain things moving forward. The critical distinction in my mind is the difference between a number of states and the federal government. Under federal law, marijuana is still illegal, and under the current administration and just earlier this month, Attorney General Sessions seemed to make it very clear that the federal government doesn't intend to change its position on that anytime soon, and probably not during the current administration. So under federal law, marijuana is still illegal, which impacts the way that employers have to address certain issues. The most obvious one is under the ADA, the Americans with Disabilities Act. A lot of employers are currently questioning, well, what do I have to do under the ADA to accommodate an employee when it comes to medical marijuana? And that is one of the questions that we can answer at this stage because of the the status of federal law. And the answer to that is, right now employers don't have to take action under the ADA to make any sort of accommodation, because marijuana is still considered an illegal drug and not a reasonable accommodation under that law. But there are a number of other issues that are raised by the fact that a number of states have recognize medical marijuana and recreational marijuana, and how does an employer who has offices or facilities across a number of states, how do they manage that? And that's where you get into the gray areas of how are we dealing with this issue.
Right, so just so our viewers are clear, the Americans with Disability Act is a federal law,
Yes.
and the federal government has prohibited marijuana use recreationally or medically.
Right.
So that's why it's prohibited there, even though some of the states may allow it.
That's correct. Currently under the ADA and the case law that has developed, and again, this is very much developing at this stage, but under what the case law that's currently developed addressing these issues, it appears that courts are taking the position of because medical marijuana is still prohibited under federal law, it can't be a reasonable accommodation to allow an employee to use the ADA to get past certain things like a mandatory drug test because of that accommodation.
Right. So one of the questions our viewers had was, what do you do if you live in a state that allows medical or recreational marijuana, but you work in a state that doesn't? Does one state trump the other?
Well, and that goes back to drafting policies that allow the employer to make the decisions that they feel comfortable making and that they want to make at this stage. Yeah, I've had a number of employers call and say, well, we recognize we don't have an obligation to do anything with regards to medical marijuana, but we want to address this in a way that's not favorable to the workforce, but gives them the most relief possible. So we want to potentially engage in the interactive process with someone. How do you do that? Well, one of the ways that I've seen employers dealing with this issue is with a zero tolerance drug policy, to draft a provision of that policy that says you only violate that policy if you test positive for a drug that is illegal in the state in which you're tested, which can be read to say if you test positive for marijuana in Florida and you can produce appropriate documentation showing that you have a prescription, that potentially there is some wiggle room as far as the zero tolerance policy. But it really comes down to employers at this stage should be looking at what their current drug policies say, how they want to address this issue. Right now there's nothing being forced upon employers that they have to accommodate this issue, but now is the time to be looking at it from a philosophical perspective of how do we want to deal with this issue, how can we deal with this issue, and the questions are difficult, but it's something that employers should be looking at now and trying to find out what they want to do and how they want to do it. And I think you can, through policies, set up certain scenarios in which perhaps someone with a condition like MS or rheumatoid arthritis or a number of these conditions in which medical marijuana has proven to be somewhat helpful for employees. How do you address that, and do you want to address that at this stage?
So it seems to me that if I own a business and I'm evaluating all of these different options that I have to have zero tolerance and follow the federal law, or have some flexibility under the state law, that really I need some professional assistance drafting that policy, because it probably has other implications, like under the Family and Medical Leave Act, under your state workers' compensation law.
Sure, and that's what we're seeing a lot of, and you know, I know from an HR consulting perspective, from a legal perspective, companies shouldn't be shy about getting advice from their consultants, from their lawyers at this stage. Which is not what do we have to do here. It's here's what we want to do. How do we set ourselves up to do that? And right now, there's currently a framework where there is some choice and there is some self-determination among employers as to what they want to do, how they want to address this issue. Now, as this develops, there may be there may be less of a choice. But right now, employers are wise to get their legal professionals, get their HR consultants involved in order to help them draft a policy or create a scenario in which they're comfortable with how they want to address the issues.
So I think you just hit on a really important point about the evolution of this. This continues to evolve, and what we're saying today may be different in 2 weeks or a month or 6 months. So really, I would think they would need continuous guidance from a professional.
Absolutely, and that's staying on top of this issue as it continues to develop is key. I know Landrum keeps its keeps people it consults with in the loop. We try to keep our clients in the loop. But it's really important for HR professionals, for companies to stay on top of these issues, continue to follow how it evolves, because we're in the first several years of this process. It'll be 5 to 10 years before I think there's really any clarity on exactly how this is going to work, and maintaining being on top of those issues during that time frame is the key to making sure that your company is in the best position possible to not only abide by the law, but avoid liability and help the workforce in the way that you deem appropriate.
Well, and this would be a good time to mention that ClarkPartington.com and LandrumHR.com are both resources that employers can look at for some newsletters and some blogs and some
Absolutely.
articles on medical marijuana, sexual harassment, what kind of policies you want to have for both.
That's right.
So
that's right.
Those are great resources that are free to anybody to look at.
Absolutely.
So let's shift gears. Let's talk about social media.
Sure.
This is an area that we've been talking about for years, and it continues to evolve. It has changed. Some of the rules have stayed the same. Some of them are not intuitive. Some of them are counterintuitive.
Right.
What's the big takeaway for social media right now for employers?
Well, social media, much like medical marijuana, or marijuana generally, it's an issue that continues to evolve as the mediums in which social media is available evolve. It also continues to evolve as we shift from different viewpoints in our government. Obviously, under the Obama administration, there was a number of issues that came out of the National Labor Relations Board to indicate that that employers couldn't monitor social media a certain way. Now we're in a different administration with a different viewpoint, and the National Labor Relations Board has shifted to where we expect a more conservative approach to allowing employers to engage or tell employees what they can and can't do on social media. So it's a continually evolving issue, and it will continue to evolve because, as we sit here today, we think of social media as certain things, and 5 to 10 years it may be something totally different. But what should employers do? Employers should look to draft policies that focus on the things that I think everyone can agree on are inappropriate on social media, and that employer must act on if they find out their employees are acting in a certain way.
Like a threat of violence.
Absolutely. Threats of violence under really any philosophy, a threat of violence towards a co-employee, towards a client, just generally is something that I think an employer can look at and with the right policies drafted, should be able to take action on. Along the same lines, derogatory comments related to your employer. If someone is putting themselves out as a employee or as a representative of a particular company, the company should have the ability to expect that they won't talk about how the company is not a good company, or
Sure.
how, and this is where it gets, but there's lines where if he talks about the conditions of employment, is that over the line or not? And that's where, again, getting your HR consultants involved with certain issues, getting your legal advice up front is helpful. But the basic thing is employers can have policies, and they should draft policies in a way to try to make clear what they expect employees to do. And ultimately, most employees will follow that. You'll always have your outliers, just like you do in anything else. But if you make clear what you expect of your employees, most employees will follow the policies and try not to create issues.
And the key is the protected concerted activity. If I, as an employee, post something on social media that the parking lot is unsafe, that probably is protected concerted activity because it's...
Currently, yes. Currently under the NLRB's approach of the last administration, any sort of concerted activity talking about conditions of employment, even wages, was the sort of issues that would get you in trouble if you were trying to monitor that or control that. That may change as the board has shifted. That may be something that employers have a little bit more leeway with. We don't know, but as of right now, I would be very careful in dealing with those issues. But if an employee talks about how a specific company produces a specific product and that product is junk and nobody should ever buy it, that's a sort of derogatory comment that I think it's not about the conditions of employment. It's not protected activity. It's something that an employer who has a policy written in the right way should be able to point to that policy and say, you violated this, and this is something that we need to address, not necessarily through termination, but through some sort of disciplinary process.
Right, or at least getting to the bottom of the concern of the employee. Why did
Exactly.
the employee post it? Because there may be something else going on that's helpful for the employer to know.
That's right.
And just to be clear, the National Labor Relations Board, a lot of questions that we get, employers say, well, gosh, we're not unionized. They don't have jurisdiction over us. But that's not correct.
That's not correct. There is the National Labor Relations Board enforces the National Labor Relations Act, which allows employees to unionize, but it also controls other issues related to concerted activity, which is a legal term of art. But all concerted activity really means is the ability of employees to get together and discuss their work conditions and their treatment. And because that is what's controlled by the National Labor Relations Act, not pure union activity, there is a lot of leeway that the National Labor Relations Board has to provide guidance that affects every employer.
So if I have one word that's a takeaway from this whole conversation, it would be policy.
Absolutely. Looking at your policies, looking at your procedures, and making sure that your HR professionals are clear on what the company wants to do and how the company wants to achieve its goals. That's the best way up front to manage issues. I always talk to clients about trying to figure out what your problems are before they ever occur. And a lot of that can be done through looking at your policies on issues that you know are at the forefront. Right now that's sexual harassment, that's medical marijuana, social media, a number of other things, but looking at it at this point in time and making sure that your people know exactly what they're supposed to be doing is the best way to avoid the really tricky issues that may lead to litigation down the road and phone calls to guys like me that you possibly could avoid if you call me up front and ask me how should we be doing this, as opposed to calling me on the back end and asking, did we do this right? I'd rather be able to guide people as to here's how you should be doing it and hopefully avoid the problem than for the problem to arise and trying to help someone get out of an issue when maybe it could have been avoided in the first place.
I agree. Being proactive can really save you a lot of heartache in the long run.
Absolutely.
Yeah. Daniel, thank you for being here. This information has been very, very helpful. Tell me how our viewers can reach out to you if they have questions on their policies.
You can reach out to through our website, clarkpartington.com. My bio is on the website with a phone number. I'm always happy to answer emails or answer phone call and help provide information on these issues or any other employment issues that may arise.
Great. We're going to take a short break and be back in just a moment.